Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about undue influence in the creation of wills and trusts, but before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. Okay. So the concept of undue influence is always present when we are doing estate planning, particularly for vulnerable adults or people who rely on others, right? So many times people in our elderly community rely on others for their care, for their needs, as well as, it could be anybody, honestly, as long as you rely on others and there's a impression that maybe you are susceptible to the influence of others. We always have then the concern of undue influence in our practice when we are preparing and drafting estate plans. And so really where the big issue comes up is in will contests after somebody passes away. Then everybody decides after they have the will and they read it and they realize that they didn't get what they thought that they were expecting, that then they will claim that one person unduly influenced the deceased person, and that's why they got a larger share, or the way things went. And so essentially the elements of undue influence are that the person was under duress, or that they had over persuasion during the process of making their estate plans, or there was some sort of force or coercion, or some sort of artful or fraudulent story that, plot that was kind of created to make the person now lose their ability to exercise their own free will and make their own choices. So how estate planners go to avoid this is we always want to make sure that we speak with our client alone, right? So not just the person who brought them to us. We want to make sure that we fill out the relationship and we have enough communication with our client individually to make sure that we are confident that what they're picking that day and what they want to set up is truly their desires, right? And not the desire of the person who brought them to our office if they were not able to travel to our office alone. So that's one way that we protect ourselves and protect the community and the client from undue influence. But that's not to say that it doesn't happen, or that it might go undetected, right? You do never know. But if you believe that a will was a product or a trust was created with undue influence and you wanted to challenge that, essentially there is a 4-year statute of limitations in Florida, but that's really not where your rub would come, because normally people challenge this, like I said, after somebody passes away, and that's a much shortened time frame because you really only have 90 days from receipt of service of a notice of administration to challenge the validity of a will in Florida. So even though we have this 4-year statute of limitations, your time frame is much, much shorter, practically speaking, because of the probate rules with regards to notice of the administration of that probate with that will. So if you think that that's the case, then you need to act quickly, and you have to also know it will be a very strong uphill battle because these are not easy to prove. It's very fact-driven, and it's very hard to prove what happened in the past, especially if you weren't present, right? You end up with he said, she said, and my gut feelings, and none of those things are really great evidence. So that's essentially undue influence. It happens. Everybody in the profession seeks to avoid it because none of us want to participate in fraudulent activities. But not to say that it doesn't happen, and therefore if you think that, that is something that happened in your family, it is something you have to act quickly on. I hope that this information has been helpful. If it has, I ask that you like and share with others. And as always, thank you for joining me.